mentioned matter from the list number 14 and 15 serial number stays till today matter. There is an entry model. And for the first case, where I am one of the defendant, its notices has been issued for limitation. And when it means 14, serial number 14 and 15 are tag matter. My lord, there is an entry model in serial number 15. And my lord, in 14, on last occasion, my lord has issued notice to some of the defendants. I have appeared, my lord. I have informed Mr. Nikhil Ranjan and Mr. Atanu Banerjee also that today I will mention it.
So that's right, they have appeared, all of them have appeared.
No, in my case, it's in the first case, some.
In 14, all of them have appeared.
No, my lord. I have seen the service report, my lord. The service report tells, my lord, that respondent number 1 to 44 and 6 and 8 in transit. That means the case service is in transit.
The office no?
Yes, ma'am.
It is as per the office no?
Most probably. Yes. I have not seen the flag, but just have gone to the office now.
Within the list, serial 89.
But this is orders case, no?
Yes,
Orders
ma'am.
cases are to be taken up for.
Madam, I'm just praying that maybe taken up as because there is an interim order till today, madam.
No, you mentioned at 4 o'clock.
4 o'clock.
You come at 4 o'clock and call Mr. Abdul back.
May I mention that serial 89?
It's the record come.
Serial 89.
18
of in the item is 89. It is there. It is SA 16 of 26.
Yes.
Ladyship, there's a, we have mentioned this matter earlier also, and your ladyship was pleased to hear that matter on the Tuesday, and it was fixed for today only. As IA first stays there, and the writ of DP has been issued, and execution is on 17th. But may be taken up before I
Yeah, for who?
for the appellant's ladyship.
Why are you mentioning on this side?
Ladyship, he was there, so I apologize.
Substantial question of law has been framed.
Yes, ladyship.
Substantial
No,
question of law.
ladyship, not has been framed.
Then it is under which heading?
It is under heading of hearing under Order 41 Rule 11.
You come at 2:15.
250.
Yes. ये वाला फाइल हमको देना 89. Unless the substantial question of law is framed, there is no question of any state. So you have to argue on the substantial question.
From tail list of understood disposal item 1, second appeal 631 of 2004.
We are covered you almost completely.
Almost. Something more I would like to see. I had shown Mr. Malod the day before yesterday some Malod evidences of the plaintiff as well as the defendant. Malod, so more evidence.
Some evidence of the plaintiff you are only referred to PW7.
PW7.
Only PW7.
DW7 I have referred.
PW7, which has been relied upon by the Learned Trial Court. PW7, just
Apart from that,
you see the scope of the substantial question of law is whether the first appellate court has met with the reasons. That is the scope.
that is
Right? There is no scope for any reappreciation of evidence. If the trial court has referred, he has relied upon defendant number 7, the appellate court has given a different finding on that. Right? then we can see that. But otherwise, everything is not open for argument.
Reasons.
Yes, reasons,
Reasons
whether the
for-
reasons are sound or not.
Yes. Day before yesterday, I had argued that the point which was formulated by one of the learned trial, the main point was whether or not the land of Khata number 33 of Mother Villa, that is issue number 7, is the proportionary property of plaintiff and defendant.
That was that was certainly the main issue, but it is absolutely integrally related to issue number 8.
Yes, both are correlated. Both are correlated.
If issue number 8 is decided in your favor, then issue number 17 naturally flows.
That what is the trial court has also said.
And that is the case also.
That is the case. Trial court has decided issue number 8 in my opinion.
That's right.
And my lord, the learned appellate court has reversed it. My lord, yesterday I had shown what were the points which were in the mind when the learned trial court had decreed this. The first and foremost point, Your Worship, was there was no specific denial. I had read out the written statement also of the contesting written statement. And so far as the
No specific denial of what?
no specific denial, meaning thereby that suppose I say that so and so is the not of son of so and so, then it is not equally incumbent on me to say who is my father.
See, you are claiming him to be a part of your family. Yes,
My-
and they say that they are absolutely out of the
Yes,
family.
but a matter that does not end there. That's what I want to say. Suppose this is sort of a vague denial. You are not specifically denying that suppose no, you were the son of so and so, you are not the member of the family. That what is it is taken.
That omission will not take you anywhere.
But
The genealogy you have claimed, it is not a case where you are pleading the genealogy of a dependent. You are pleading your own genealogy.
yes,
So you have to prove your own genealogy.
and to prove my own genealogy, I have brought on records the evidences, oral evidences that has been relied upon by the so far as the plaintiffs are concerned. Plaintiffs have categorically pleaded and proved also.
The trial court has not given much reliance on that. There is no discussion.
The discussion.
एक PW7 के अलावा किसका डिस्कशन?
हाँ,
बताइए।
बताइए।
नहीं।
सबसे पहले तो डिपेंडेंट नंबर 3 का कंसीडर किया, दैट इज पेज 11.
अरे डिपेंडेंट नंबर 3 का प्लेंटिफ का एविडेंस बताइए ना, दैट प्लेंटिफ हैज प्रूव्ड। डिफेंडेंट का एविडेंस पर आप अपना केस थोड़ी बना लीजिए। प्लेंटिफ का एविडेंस
ये तो ये बोले ना
It is in 3 or 4 pages from starting from page number 9. You just see. Defendant का evidence से plaintiff का case को demolish मतलब establish कर admission नहीं है. There is no admission.
Trial court has considered one another aspect.
No, पहले आप इस point को note करिए. Has the learned trial court by deciding issue number 8 discussed the evidence of the plaintiff?
Plaintiff's oral evidences have not been discussed.
Let's take it. Let's take it.
But it has considered the evidence of the defendant.
Just a moment. You see, so far as the evidence of the defendants are concerned, most of them are not family members.
But they are aged persons.
Sorry?
Aged persons.
Age persons means what?
Resi-
पड़ोसी के बाप का नाम पता होता है?
Residing in the.
No, maybe. You see, पड़ोसी के पिताजी का नाम पता होता है सबको.
लेकिन अगर आप
जो एक डिफेंडेंट who was examined, उसको तो कोई क्वेश्चन ही नहीं पुट किया. उसको ना क्वेश्चन पुट करना. नहीं किया है. DW, I do not know who is he, and evidence of defendant witness से कुछ नहीं.
प्लेंटिफ विटनेस का भी हमारा एविडेंस है.
है. The point is whether the appellate court has met with the reasoning of the trial. The trial court has not discussed any evidence of the plaintiff.
प्लेंटिफ का
And the appellate court has discussed the evidence of the plaintiff. What else is required?
बट द रीजंस
को भी डील किया.
रीजंस को जो डील किया है उसमें जो स्टार्टलिंग
देखिए कोई एडवर्स पोजीशन मतलब एडवर्स इन्फ्लुएंस नहीं हो सकता कि डिफेंडेंट ने अपने बाप का नाम नहीं बताया.
नहीं हम ये
इससे
चीज
कोई एडवर्स इट इज योर फैमिली. आपके पिताजी, दादाजी, चाचा जी जो भी हैं ये सारा कुछ आपको एस्टैब्लिश करना.
नहीं तो हमने कहा है अपने
नहीं.
एविडेंस में अगर हुजूर का
The point is, trial court has not discussed it.
maybe
Yes.
but my evidence is on record.
No, there is no question of reappreciation. The point is that there is one evidence with the trial. I can understand that trial court has discussed this evidence, and on the same evidence, after discussion, the appellate court has reversed the finding. It is another thing. It is one thing to say that the trial court has completely ignored the evidence. The approach of the trial court is absolutely lopsided. The trial court has taken as if it is the defendant who has to prove. No,
नहीं.
the approach is incorrect.
But if suppose the approach is not that perverse, your lordship may kindly appreciate. I said I have stated something on Malad in the claim. If somebody is denying, they are saying, I am not saying.
You see, it is your family. This is very, very important.
It is our family rather.
It is your family and you have to prove the
It is
genealogy.
our family, I would like to say.
Yes.
It's
No,
our-
not our family. Because they say that they do not belong to your
If
family.
suppose that what I am saying, if they say that it is not,
No, I don't agree to this. I don't agree to this proposition at all.
merely, Malad,
No.
merely by saying, can it be proved? After all, what
So
is
therefore, merely by saying that he is my uncle, can it be proved? Who has to prove it?
I have brought certain documentary evidence, and Malad, I have also brought certain oral evidence. And the trial court, after analyzing each and everything, has come to a finding.
No. Trial court has not done that.
Malad, I have.
Trial court has referred to the evidence of the defense witnesses and certain cross-examination and the written statement of the defendant that they have not particularly pleaded or whatever, right? And on that ground, the trial court has passed it.
Malad, may kindly see two or three.
And the appellate court has taken everything into
Two or
consideration.
more things that I would like to show here. Your lordship may kindly see here.
अब बैठ जाइए अभी आपकी
Issue
बारी।
number 7. Issue number 7.
Issue number
7.
7.
Whether the land of the Khata number 33 of Badar Vela is a personally. This is a very important issue. The lordship may kindly see here. One document one of the defendants have brought on record, that is Hiban. I can read out the discussions if you lordship will permit me.
Exhibit B.
Exhibit B. which
जिसमें
has been-
लिखे हैं कि मेरे भाई जैसे हैं,
जी
मेरे भाई जैसे हैं।
मैंने लेवर है लिखे लेवर लिखे
देवर है नहीं लिखे, देवर जैसे हैं।
हम आपको डॉक्यूमेंट दिखाते हैं और उतना ही नहीं, उस पर्टिकुलर डॉक्यूमेंट में सोकरियार भी लिखा है और ये लोग सब सोकरियार हैं।
भाई एक सरनेम होने से जितने यहाँ पे शर्मा जी हैं सब आपके रिलेटिव लगते हैं क्या?
नहीं लगते।
नहीं लगते ना, इसीलिए सरनेम से मैं किसको बोल रही
नहीं, लेकिन जब आप एक डॉक्यूमेंट से हमें कोई गिफ्ट कर दें,
डॉक्यूमेंट में इसी घर के आसपास कोई लोग रहते हैं, वो मेरे भाई जैसे हैं और भाई है में बड़ा फर्क है।
नहीं फर्क
बहुत जमीन आसमान का फर्क है।
वो हम मान रहे हैं। लेकिन अगर मेरा ऐसा केस है और हम अपना केस के बाबत ये चीज अगर हम ला रहे हैं और इस तरह का एविडेंसेस आया है,
अच्छा, एक बात बताइए।
कोइंसिडेंस तो नहीं हो सकता।
According to the evidences placed on record, the entire property, nothing remained. Partly gift हो गया, right? और partly sale हो गया। बचा क्या partition के लिए?
कुछ
बस कुछ कहाँ से बोल रहे हैं आप कुछ?
इसमें है, दिखाते हैं।
नहीं, ऐसा नहीं होता। It's not like this.
सबसे पहले तो गिफ्ट का 1944 में अगर ये पर्सनली प्रॉपर्टी थी तो सोमली को पाबंदी नहीं।
तो आपने गिफ्टेड को चैलेंज किया है? Is it under challenge?
हमने तो पार्टीशन के दौरान अपना 1/3 शेयर मान रहे हैं।
मांगा है
अगर आपको
प्रॉपर्टी
अगर आपको गिफ्ट अगर हुआ भी है, हम 1 मिनट के लिए मान लें, और ये एक पर्सनली प्रॉपर्टी है, तो आपका जो टू योर एक्सटेंड टू द शेयर आपका होगा, बाकी तो हमारा भी होगा। जो
भाई आपका तो पूरा सूट इस बात पे खत्म हो जाता है
जी।
कि वो आपके रिश्तेदार ही नहीं।
नहीं, रिश्तेदार
तो क्या
ये
चीज़
कह
का
रहे
partition
हैं,
होगा?
ये कह रहे हैं
क्या चीज का पार्टीशन?
हम 2 चीज का पार्टीशन मान रहे हैं। एक तो खाता नंबर 22 का है, दूसरा
उसका तो
खाता
आपको
नंबर
कोई लड़ाई
33
नहीं
का है। 33 का
22 से तो कोई लेना देना नहीं है ना।
नहीं, लेना देना है। हम तो 1/3 उसमें भी चाह रहे हैं, इसमें भी 1/3 चाह रहे हैं। और हमारा कहना है कि ये टोटल प्रॉपर्टी जहर महतो की थी। जहर महतो के 4 लड़के थे, जिसमें से भीखो एक था। भीखो के बाद उसका लड़का बोंदी सुकरियार था। बोंदी सुकरियार भी वाज आल्सो पार्ट ऑफ द फैमिली। ये सारे डॉक्यूमेंट्स को कंसीडर करके लॉरेंट ट्रायल कोर्ट ने इस पॉइंट पर कहा। इनका विटनेस भी इस चीज को एडमिट कर रहा है, जिसको हम कल दिखाए। और वो एक इम्पोर्टेंट
DW7 has said कि ये लोग सब चचेरे भाई हैं।
हाँ भाई है कर रहा है।
But the point is that even if your case is considered, they are the uncle at best.
बोली तो जो भिखारी का चचेरा भाई ना लगेगा। अब मानिए अपना सब लोग अगर उनके लड़के वारिसान अगर मान लीजिए हुजूर अगर प्लेंटिफ है, तो सब तो एक दूसरे के चचेरे भाई ही लगेंगे।
नहीं लगेंगे ना, कोई अंकल लगेगा, कोई दादाजी लगेंगे,
नहीं ठीक है,
कोई ग्रैंडसन लगेगा।
लेकिन जिस कॉन्टेक्स्ट में उन्होंने कहा है, अगर मान लें चचेरा भाई अगर इसमें अगर गलती हुई तो भाई तो है।
भाई कैसे हो जाएंगे?
नहीं, कैसे है?
नहीं, he is according to the genealogy he is uncle, not brother.
इसके बारे में कह रहे हैं ये चीज, इसके बारे में जैसे अगर ये इस पॉइंट से ट्रायल कोर्ट का ये कहना कि इससे रिलेशनशिप प्रूफ हो रहा है, इस बात इसमें जो हमारा इसमें इस पर कोई डिस्कशन भी अपीलेट कोर्ट का नहीं। हमने हुजूर को कल वो एविडेंस दिखाया था, वो चीज़ में तो कोई इनका कोई नहीं है। अब रह गया जैसे एग्जिबिट बी, तो एग्जिबिट बी जो है, एग्जिबिट बी में एक बार हुजूर एग्जिबिट बी तो रिकॉर्ड पर भी नहीं है, हम कल देख रहे थे। I tried to find it out.
ओरिजिनल तो आपने सारे निकाल लिया है, तो कहाँ से मिलेगा?
नहीं तो इतना निकालेंगे हम, क्या निकालेंगे?
जो भी है,
कम से कम फोटोकॉपी भी तो रहना चाहिए।
कोई बात नहीं, उतना हम लोग नहीं देखेंगे। हम लोग खाली देखेंगे कि रीजन मीट हुआ है।
हमारे पास है, इसको आप देखा है।
कोई परवर्सिटी का ग्राउंड करके तो कोई ग्राउंड भी नहीं बना है। व्हाट डू यू वांट टू रीड? एग्जिबिट बी का जो कंटेंट कोटेड है एप्लेट कोटेड।
हम देख अच्छा, इनका एक गवाह जो कि दूसरा चीज कंसीडर किया था जो कोर्ट ने, इनका गवाह जो कहा है कि हमने श्राद्ध के समय बेचा है, तो अगर कुछ था ही नहीं, कुछ था ही नहीं, तो क्या चीज का जमीन बेच रहे हैं? श्राद्ध के समय
क्या हो गया श्राद्ध के समय बेचने? You
दोनों
see
दोनों
the-
पार्टी ने बेचा है।
Just a minute. You see, the point is that they were very closely related to each other, but not related by blood. There is a difference. The kind of relationship which has been shown. They were very close to each other. तभी कोई अपना property किसी को gift करता है.
That is not the case pleaded by them.
That is
But
the
what is the
case.
case pleaded by them? That they are agreeing so far as the khata number 22 is concerned, because they are using the name of all the three brothers. But so far as the khata number 33 is concerned, they want to grab it, and to grab, they are saying that no, he
Khata
was
number 22 has been directed to be partitioned
yes, by the trial court.
by the trial court amongst whom?
Amongst the three persons, all the three, after death of Bondi Sukriya, but not the agents, all the three agents. I am also one of the agents, but not the another defendant, another set of defendant who is supporting the plaintiff is also an agent, and but not the contestant is also an agent.
It is sought to be partitioned on the ground that they belong to the same family.
Yes, so far as khata number 22 is concerned.
Show me that with respect to khata number 22, there is a finding that they are from the same family.
Yes, I am sorry.
So for one khata, they will be from the same family, and for the another khata, they
Then
are
what
not.
is their case?
Show us,
Yes,
please.
yes.
Show us from khata number 22. The name of Bundia's Sokiar is not there in khata number 22.
So far as the khata number 22
उनका नाम ही नहीं है.
concerned, it is the name of all the three, the agents itself. Sons Hulas Mahato, Vikari Mahato, and one another brother. And khata number 33 is entirely in the name of Bondio Sukriya. But the learned trial court has said that so far as the khata number 22 is concerned, everybody had one third share. But so far as the khata number 33 is concerned,
Everybody means this Bundia
all the
Sokiar also.
no, Bodia Sakariyar is already dead. So all the three agents, I'm referring all the three agents. And rather, learned
All the three agnates, they will get the property
in the khata number 22.
in khata number 22,
Well,
including defendant number 3 and 6.
including 3 and 6. That was the decision made by the learned trial.
Because
Learned
that was so because the learned trial court found that there is a relationship and they belong to the same family.
With respect to 20.
With respect to 20, the court first decided that they belong to the same family, right? And then the court considered khata number 33 and khata number 22. So the basic finding is whether there was a relationship or not.
So far as the trial court your lordship is concerned, trial court concluded there was a finding.
That's right.
Yes.
That finding has been reversed by the
That
learned
has been
appellate court.
reversed. But
And therefore the entire decree has been reversed.
yes, so far as the appellate court your lordship is concerned, my lord may kindly consider. Appellate court has said that the khata number 33 is not a joint family or not a co-pastoral property. That is the first point. Second one, my lord, so far as the 22 is concerned, my lord, learned appellate court has reversed also on the ground, my lord, that though there is a, my lord, there is no dispute in the genealogy, but as because there is separate kabjawari, there is separate and everything is partitioned, so there is a previous partition. This is what is the entirety the appellate court has done. So far as my submission is, so far as the khata number 22 is concerned, genealogy has not been disputed. Appellate court court is disputing with respect to Khata number 33 only. And that is what the defendants are also doing. And so far as the previous partition, Your Lordship is concerned, my Lord has yesterday taken notice of this, because the written statement filed by the defendant number 3 and 6, the contesting one. My Lord, they were not happy with it. So this was entirely a new point at all. And there are judgments, Your Lordship is aware, I will show those judgments, 99 Patna, that even if there is separate entry in the revenue records or the Khatyan, that can only an incidence, that can only an instance that there are separate, but it does not mean that by meets and bounds the submission. So these are the nature of the dispute, and so far as the trial court, Your Lordship is concerned, trial court has agreed, and the ground was that there is no specific lab. And they did not mention neither in the plaint nor in their evidence, despite being repeatedly asked that you say who is the father of, if suppose the Jewel Mato was not the father of the Bhikkhu, then who was his father? Then they have considered and they have said no, that is not. One evidence I would like to show, nothing more, because I have already asked. Won't take much time. My Lord, I would like to read out the evidence of DW1. He is the witness for defendant number 3. Gunduru. Your Lordship may kindly see the cross-examination. Para 10 I would like to read. भिको सुकरियार का बेटा बुदिया सुकरियार के मृत्यु बंदरवाल. He is admitting it. DW10, DW1. He is admitting it. भिको सुकरियार का बेटा बुदिया सुकरियार के मृत्यु बंदरवाल.
There is no discussion of evidence of DW1. Does the trial court say that DW1 has admitted? There is a discussion of evidence of DW1 by the learned trial court also. The court has not come to a finding that DW1 has admitted.
Court has taken into consideration
No,
DW7. But I am showing that DW1 has also admitted. And para 12 has been taken into consideration by the learned trial court. सोमरी का श्राद्ध कहते हैं तो खाता नंबर 33 का 8 डिसमिल जमीन चूटर महतो का लड़का देवा महतो एवं मेरे पिता रूपन महतो ने बेचा. Both parties have sold it. And learned trial court has taken this point in the favor of the plaintiff, that if there was no relation, where was the occasion to sell off the land?
So this statement will establish the genealogy.
But these are the instances. These are the instances, Marat, to suggest one, and taken not by the trial. And in para 10, their evidence.
See, you have to show it from the improved judgment. Where is the discussion of evidence of DW1 by the learned trial? We are not going to reopen all your evidences and see. We are not.
The reasons you are
But we will see that. We will see the reasons.
Maybe.
We'll see the discussion. Let us see whether the trial court has relied upon the evidence of DW1 and to what extent.
I'm sorry. Yes. DW1. Maharaj, may kindly see page internal page 12.
Yes.
DW1, Nandu Pato is the contesting defendant himself. And he had stated in para 11 that he was the person who performed the Srad ceremony of Somri, who was the Bodia Sokariyar, and at that time the witness was aged about 15 to 20 years. And furthermore, in the following paragraphs of his deposition, further permitted to meet out the expenses of ceremony. His father, Rupan Mato, and Deva Mato, Chuta Mato, had sought out 8 decimals of land, which means that he is referring to land of the Somri, which is item number 1 of Khata number 1. Now the question arises when he had no right or the interest on the land of the Khata number 23, that in what prompted or authorized him
Which
to make
means
the
how
transaction.
is it referring it to this particular property?
But
How is he referring that it means that it is the land of the Somri which has been sold?
then what is the transport?
Does the DW1 say that the Somri's property was sold?
11 तक वो महीना
DW1 के एविडेंस में है कि कौन सा प्रॉपर्टी को बेचा था?
था 33 तो भूल लिखा है
कौन सा सेल डीड से?
33
Did they exhibit any sale deed?
Deed is not. But it is his business.
अरे भाई जब आप बोल रहे हैं कि एक प्रॉपर्टी बेचा था, उस प्रॉपर्टी का सेल डीड क्यों नहीं लगाए?
Correct.
Because the appellate court has taken adverse inference on this, that this document has not been exhibited.
Yes.
Yes.
But the question, Your Lordship, where is the question of taking an adverse inference?
It's absolutely-
My lord, may kindly appreciate.
No,
It
it's
is the evidence of the DW. How can a court can take an adverse inference with DW? My lord? Had it been my witness, and my lord, had I said something, and I could not support it, my lord, by producing the sale deed, that could have been done. But it is his witness, my lord. Your Lordship may kindly appreciate. And apart from that, my lord, para 10 I had just shown you. So far as the genealogy part, Your Lordship is concerned, that admission is itself there. It is one of the contesting defendant, my lord, Gundur Mathur. He is saying that because Sukariyar का बेटा बोथा सुकरियार की मृत्यु 15 बार में हुआ है. What more is required? There is an admission on his part. Thereafter, my lord, the trial court has considered evidence of DW7, which I have already yesterday, day before yesterday, I have already and defendant number 10 to 13 are also, my lord, they are the sons of Vilas Mathur. They are supporting the Flint. They are also saying that yes, Vico was son of Jihad, and they are also entitled to one third. When the partition is made, so one third they are entitled. I agree to that extent that it is a very detailed judgment passed by the appellate court. But appellate court, Your Lordship, has taken into consideration certain evidence on record to reverse the finding. But point which, my lord, was relied upon by the trial court has not been specifically answered. That what is that was the reason, that is the point of law which has been formulated at the point of at the time. And so far as the Khata number 22 is concerned, there is no dispute that all the 3 sons are sons of Jugal Mathur, and there was no reason for the appellate court at least to set aside this sale. Without having even pleadings of this petition. So that part here is absolutely.
So you just enumerate one by one, right?
Yes.
One, you enumerate that the trial court has relied upon the WS of defendant Contesting defendant?
Yes.
You
As
just,
well
you
as
just
the-
enumerate
I-
because I have to dictate that.
As well as the written statement of the supporting the defendants. They are also one of the question. 10 to 15.
The trial court has not, while discussing issue number 8, the trial court is not referring to any of the written statement of the non-contesting defendants.
Yeah, he has referred.
While deciding issue number 8, para number 12.
Yes. It shall not be out of place to mention that the defendant 10 to 15 have also filed separate evidence, though this has been admitted.
Did they need any evidence? Did they need any evidence?
They did not need.
They did not.
But they have supported.
They are non-contesting, they also want a share.
No, I want to say that they are supporting. The only
They are
contesting.
non-contesting, they are supporting, they are kind just unlike pro forma defendants. Their status is that of a pro forma defendants.
But they are also seeking partition.
That's right, for partition they are there,
seeking shares.
and they have not led any evidence as such.
As such,
They have not led any evidence.
but not opposed also. They have admitted the genealogy also.
They will, they want to share, they will. Naturally they will,
Yes.
because they want to share in the property.
Yes.
So it is a very natural conduct on their part.
Yes. Yes. The ground for not on which the appellate court has reversed it, at least it was ground.
No, so far as the learned trial court is concerned, you are referring to exhibit B, right? Then number 2 is exhibit B, the written statement of defendant, and number 3, evidence of DW1 and DW7.
Sir, and others evidence has also been taken.
No, others नहीं बोलिए, आपको जो specific बोलना है, आप specific ऐसे general statement मत लीजिए.
Exhibit B and C have been considered by the trial court, and those findings have been reversed.
That's all?
That's all.
That's all? Parent का submission
It's for the element of appellate court. Findings, Your Worship, starts from page 7. That is 4, 5 and 6. Issue number 4, 5 and 6. There is no dispute with respect to parties with regard to ancestral. Number 22. It is also says. ये फंडिंग में कह रहे हैं कि कोई डिस्प्यूट नहीं उसके बावजूद भी सब्सिडाइड किए आटा 33 पर ही कंसिडर की और 15 में इसके बाद इनका मीटिंग्स वगैरह कंसिडर किए और डिस्कशन किए पीडब्ल्यू का भी एविडेंस को डिस्कस किए पीडब्ल्यू 1 का भी किया लेकिन पीडब्ल्यू 1 का जो रिलेवेंट पारा है उसको ये नहीं डिस्कस किया जो देखा जाए पारा 12 में देखा DW1 in para 14 has stated that Rupan Mahato, Benny Mahato has accepted deed of the gift executed by Musman Somni by putting their signature and coming in possession of the gift evidence. Para 15 has stated that 2.60 acres was sold by Somri and one purchaser was granted to other tutor. Para 16 stated that after death of Somri, all the parties have sold out some land in 33, which is obviously seen by one of the but has not discussed para 10, which was very, very relevant para. उसके बाद सेडिट पर आए C1 पर DW7 का जो मेन एविडेंस जो ट्रायल कोर्ट ने कंसीडर किया
नहीं एक सेकंड DW1 का पैरा 10 में क्या बोले
para 10 में तो उसका जीनियोलॉजी को एक्सेप्ट कर
ने जीनोलॉजी को कहाँ है
हम अभी तो दिखाए थे बिको सोकरियार का बेटा बोधिया सोकरियार की मृत्यु बंदर बाद में हुई तो खुद कह रहे हैं कि इनका लड़का था बिको सोकरियार का बेटा बोधिया अगर बीइंग एन अपीलेट कोर्ट कम से कम जब सब पारा देख रहे थे तो 10 भी तो देखना चाहिए था
पैरा 10 पढ़ी
बिको सोकरियार का बेटा
बिको सोकरियार
का बेटा बोधिया सोकरियार की मृत्यु बाद बेला में बिको सोकरियार का लड़का बोधिया सोकरियार ये बात तो ये एडमिट कर रहे हैं ना अपना उन्हीं क्रॉस एग्जामिनेशन में इनका तो कहना है कि कोई है ही नहीं था बिको का कोई नहीं था बोधिया अच्छा जुएल को हमारा भी
नहीं इम्पोर्टेंट ये नहीं है ना इम्पोर्टेंट ये है कि भीखू सोकरियार उनके बेटे थे जो कॉमन एंसेस्टर डिस्प्यूट तो वहां पर है डिस्प्यूट इस पर नहीं है कि वे उनके बेटे थे डिस्प्यूट ये है कि वो उनके बेटे थे कि नहीं थे जो कॉमन एंसेस्टर डिस्प्यूट वहां पर है it takes you nowhere ये डिस्प्यूट है ही नहीं See, आप अपने इसमें आइए that is not the dispute बीको सोकरिया जेहन महतो के बच्चे थे कि नहीं थे ये डिस्प्यूट तो आप कैसे बोल रहे हैं कि जीनोलॉजी डिस्प्यूट
स्पेसिफिक इनसे सवाल पूछा
वो अलग बात है लेकिन आप बोलते हैं एडमिशन है तो एडमिशन तो नहीं है ना
एडमिशन है ना
वेयर इज द एडमिशन दैट बीको सोकरिया वाज द सन ऑफ जेहन बस उतना एडमिशन दिखाई दिया उसी एडमिशन से लेना देना है
DT.15.01.2026 का एविडेंस तो ट्रायल कोर्ट ने रिलाई किया था, जिसमें इनसे पूछा गया था, तो इन्होंने कहा था कि अपना पारा 3 में ये एविडेंस कमीशन इन चीफ में कहे थे कि जेहल महतो का नाम मैंने सुना है, जेहल महतो का बेटा भिखारी महतो है।
देखिए आप एक विटनेस के एविडेंस से दूसरे विटनेस के एविडेंस पे मत जाइए. There is no evidence in DW1 to say that Bhiko Mehto was the son of Jehel Mehto. There is no evidence. Rather, this witness in his cross-examination has denied.
हमारा एविडेंस तो है,
आपका एविडेंस ट्रायल कोर्ट ने ना डिस्कस किया है.
ट्रायल कोर्ट में जो
कुछ नहीं.
consider किया
No
था,
discussion. No discussion of your evidence. खाली डिफेंडेंट का एविडेंस से प्लेंटिफ का केस बनता है. And in cross examination, this DW has denied कि इनके 4 बच्चे थे. हाँ, पैरा 25 अब DW1
ये तो हो गया जो इसका पारा 26
25 को omit मत करिए.
पारा 25
25
CW is edit बाजार
नहीं 25 उसके जस्ट ऊपर दो पैरा 26 पेज नंबर 11 का पैरा 25. ये सत्य नहीं है कि जोहर महतो के 4 लड़के.
JW1
हाँ? ये सत्य नहीं है कि जोहर महतो के 4 लड़के.
पारा 26
25 से आपको कुछ फायदा नहीं होगा.
पारा 26 जो एक बार ट्रायल कोर्ट में सुप्रीम कोर्ट का जजमेंट है. इनका कहना है जो अपील कोर्ट का कि so far as the खाता नंबर 22 of the tonight to the concerned parties have been independent and dealing with their respective shares. Hence there is a strong evidence to show that there is a privilege partition. इसी ग्राउंड पर इसको
आगे भी पढ़िए ना, आगे भी पढ़िए. Exhibit D is खाता
खाता 33 of Bandarwela which is recorded in the exclusive name of Budia Supriya. Whereas खाता number 22 is jointly recorded in the name of sister of the plaintiff and does not include the name of Budia
Yes.
Supriya or his father.
Yes.
I am confining my argument right now under 22. 33 पर तो नहीं मानते तो हटा ही, लेकिन अगर 22
नहीं
का
22 में भी he says that it does not include the name of Budia Supriya.
But so far as the खाता number 22 is concerned, 22 they are admitting that it is a property.
No, there is no admission. Admission तो आप बोलिए ही कुछ admission नहीं.
They have 22 पर तो इनका admission है. पर
क्या?
no doubt.
So that it is a joint family property of the this
हाँ,
person
हाँ,
also.
हाँ,
कौन सा admission है? दिखाइए कौन सा पैराग्राफ में 22 में admit किए हैं.
22 में इनका ये कहना है.
इनका तो सीधा सीधा ये कहना है कि हमको इस फैमिली से कोई लेना देना ही नहीं.
Not with respect to खाता number 22.
Even with respect to खाता number
No.
22. In खाता number 22, these contesting defendants are not claiming anything.
The contesting defendants are saying that इनके बारे में इनका
It is not even their case that खाता number 22 belongs to them.
नहीं this is there. तो है तो उस पर तो कोई डिस्प्यूट ही नहीं है, सोई का. हाँ जिसमें इनका रिटर्न स्टेटमेंट देखा जाए, रिटर्न स्टेटमेंट देखा 22 पर तो इसमें कोई डिस्प्यूट ही नहीं है.
आप इम्प्यूट जजमेंट से पढ़ाइए ना.
हाँ, पढ़ा रहे हैं.
इम्प्यूट जजमेंट से पढ़ाइए कि खाता नंबर 22 में इनका कुछ होगा.
तो इसी पहला ही लाइन में लिख रहे हैं देखा जाए. So far as the land of Khata number 22 of village Donaipur is concerned, land parties have made independent transaction and are dealing with their respective share. Hence, there are strong circumstances to show there was a previous partition in Jharkhand. Exhibit 3 is the Khatiyan of Khata number 33 which recorded in the exclusive name of Gondia Khatiyan, whereas Khata number 22 of village Gondia is jointly recorded in name of the ancestor of the plaintiff and defendants. साफ तो लिख रहे हैं
jointly recorded का मतलब ये
jointly recorded का मतलब है कि हमारा
jointly recorded का मतलब ये नहीं होता है कि that they are related.
नहीं
Relation by blood
खाता
is
नंबर
different.
22 में तो हुजूर कोई डिस्प्यूट कर भी नहीं रहे। इसमें ट्रायल कोर्ट ने इसमें 1/3 कहा था, अपील कोर्ट ये कह के कहती है कि नहीं देयर इज ए सेपरेट डीलिंग्स एंड कब्जवारी सेपरेट है, हम पढ़ देते हैं। Whereas the Khata number 22 of village Donai Court is jointly recorded in the name of the sister of the plaintiff and does not include the name of Bulia Superior or his father. Even the separate possession of plaintiff and defendant and sister have been recorded with respect to Khata number 22. Both parties. Both the Khatiyans of such and such are documentary evidence to show that their father did not belong to the Jihar Mahto as claimed by the defendant. Defendant number 3 and 6 have paid rent to the ex-landlord and to the state of Bihar. Exhibit A series. Exhibit B series is the gift deed disputed by Somri. Learned counsel for the respondent has laid less stress on one sentence, gift deed as a junior like brother, but in this sentence the learned counsel has tried to connect Musmat Somri with family of the jailer to show that her husband was a common descendant. This such type of relationship is very usual in the village where every person refers in the village by term of relation. Therefore, it is natural that Musmat Somri has described the doings of this one of the sentence, straight sentence cannot establish the fact that the husband, Bulia Superior or his father, both belong to the family of the. If their Khatiyan as well as Khatiyan are separate from the plaintiff and the defendant could not establish either Biko Superior or the Boda Superior, family of the joint family of the plaintiff or the defendant. If this was the fact, there was no reason why the name could not have been included in the Khatiyan along with ancestors. Rather, Khatiyan is the Bulia Superior is recorded in his sole name for Khata number 23. But his name does not find place in Khatiyan of the plaintiff ancestors of Khata number 22. None of the witnesses examined on behalf of the plaintiff stated that they have seen Bulia Superior or his father Biko Superior in village Bundabela. EW1 at 80 years at the time they have claimed that the Bulia Superior is located in Para 11 of Mahto. Rupan Mahto used to live near the house of Muhammad Shukri, which means that the both of them are opportunity of living after Muhammad Shukri in his old age, due to which he stated deed of gift in their favor. PW3 further stated Muhammad Nanu Mahto are all sons of Jairam Mahto and no share. He has further admitted that Bigo Mahto was not of family of the Jairam Mahto. Similarly, PW5 Johan Mahto admitted he neither seen the Jairam Mahto nor Bigo Mahto. He has further stated in Parasri that he had no land or house in Bundabela, nor he had seen the land of Khata number 22. In Para 8, he has admitted that it was Chutar Mahto and Deva Mahto who had sold him, so that Bigo Mahto was son of the Jairam Mahto. Therefore, as discussed above, I find that there is absolutely no evidence on record to connect Bulia Superior or his father Biko Superior with the family of the Jairam. Plaintiff have not been able to prove that they were members of joint family property. Jairam Mahto and their property liable to be divided. In fact, it would have been same family. There is no reason why the plaintiff ancestor includes 60 pockets of land from Musmat Shukri, Khata number 33 of Bundabela. The said deed was subsequently acted upon of the custodians by disputing another said deed. Ancestor Chutar Mahto is one of the custodians from Musmat Shukri and later his wife Bhavani, along with Musmat Shukri, wife of Nanu, had disputed said deed. Right, exhibit C/1. In C/1, there is a reference of the said deed of 84 disputed by Musmat Shukri in favor of ancestor of the plaintiff. Therefore, plaintiffs are stopped by their own conduct to challenge the deed of gift or said deed disputed by the Musmat Shukri. However, plaintiff have not challenged or made any belief to set aside the deed of gift for this wedding. Learned counsel for the respondent has remarkably argued and pointed out the evidence of the oath to show that the Buria Supriya died in 1934 and Musmat Supri had no right to eliminate his grandfather's property. He has also laid down great stress that the Musmat Supri died in 1954. Therefore, whatever right you have during the lifetime did not become. I do not find any deficiency in all the submission. Therefore, discussed, I have already read that neither Musmat Supri nor husband nor her father-in-law belong to the family. On perusal of Khatian, Exhibit 2 of ancestor of plaintiff and defendants are find the lands are separately recorded in the name of all the three sons of Jharkhand. They are Bhikhari Mato, Vilas Mato and Mato. Their separate possessions over the land of Khata number 22 of Bunai Kodu has also been recorded as per Diwali Dakha. This goes to show that even during the cadastral survey and settlement operations, all the three sons of Jharkhand Mato separate, due to which their name and position over the ancestors were recorded separately in the Khatian. This is the most important piece of evidence to show that there was a previous partition among the three sons of Jharkhand. And therefore, both the parties admitted that they are in separate cultivating position according to their community. The evidence on record go to show they are separate in mass, residence and cultivation. They have been conventing over the share of the separately, which is an important factor to prove previous partition. So far as the land of Khata number 33 of Bandarbera is concerned, I hold, they are not the joint family property of the plaintiffs, defendant. Rather, it was separate property of Buria Supriya, son of Bhiko Supriya. This was in the predatory death transacted by Musmat Supriya. Rupan Mahato and Benny Mahato acquired right title position over the land gifted to them by Musmat Somri by Exhibit D, and while Chutar Mahato, ancestor of the plaintiff, acquired right title and position by virtue of his purchase in the year 44. Exhibit C, Musmat Somri is the only surviving legal heir of family of Bhiko Supriya, and she had all full rights to his school, gave it and sold it. On discussion, the entire overall agreement between and hold, there is no unity of title and position with the parties and defendants over the suit. With 33, there is a finding that they are not connected. So far as the 22 is concerned, the finding is that though they are connected, but because of separate Kamjawari, separate Khatiyan, there is no finding.
They connect in the sense that is only the court says that different Kamjawari is recorded with different persons in that particular property, right? And therefore there was a previous partition.
That what is the finding?
That
Those-
was the finding. And apart from that, the court has also recorded that the relationship has not been proved. That is also recorded, isn't it? It is not that it is not recorded.
Relationship, so far as the relationship with respect to 22 is concerned, they are admitting it. They are not denying it.
No, they are not
Allow
admitting
them
it.
to argue.
They are
Allow
not
them to
admitting.
argue.
No, when you say that they are admitting, you show the admission.
Question is, my lord, if suppose my lord may candidate, in the Khatiyan, there is a name of three sons of Jharkhand. They are not disputing that he is not a son of Jharkhand Mato, I am not a son of Jharkhand Mato, or another former defendant.
There are only cases that Bhiko Sophia,
That
Bhiko
is
and Budia are one and the same.
That is with respect to Khata number 33.
No. The question of partition will come only if Bhiko and Budia are Bhiko and Budia are one and the same person.
Don't make idea.
Bhiko and Budia are one and the same person.
Bhiko is the father, Budia is the son.
Okay, Budia is the son. The question of any partition would
Question
arise
of any
only
partition
if
with respect to
Bhiko is
33 only.
no, even with respect to any property for that moment.
No, so far as the 22 is concerned,
You see, the name of Bhiko is appearing in 22?
no.
Not appearing.
No, not appearing. But the name of the three sons of the Jugal is appearing.
That's right.
And he is also one of the sons, I am also of the son.
If the name of Bhiko is not appearing in Khata number 22, then how is Bhiko entitled to any share in Khata number 22?
We are not asking a share so far as the Bhiko is concerned. Bhiko is concerned with 33.
Yes.
And
Bhiko is not concerned with 22 at all.
Yes, that what I am also saying.
Yes.
So far as the Khata number 22 is concerned, it is a land of about 10 acres in lot. It is in the name of the three sons of the Johar Mato.
That's
That,
right.
that is not denied. The learned trial court
That's
has
right.
not granted decree. But with respect to Khata number 22, item number 2, one third.
That's right.
That has also been set aside on the ground that there is a separate kabjawari and because of separate.
Yes, that particular finding we will see what is to be done. But
Yes.
so far as the private, the defendant number 3 and 6 are concerned,
But
who are in which is in relation to Khata number 33, that is a separate thing.
so Khata number 33.
So far as Khata number 22 is concerned, one third share with respect to Bikari, Pulsa and Nanu, which has been decreed by the learned trial court.
There is no present, but what I am saying.
So there was no such plea that there was a previous
And
partition
there is no opinion also
to set aside that finding.
to set aside that.
The appellants were, who were the appellants before the first appellate court?
I will give.
Before the first appellate court.
First appellate court, but I am they were.
They means who?
They means the defendant contesting.
Contesting defendant. So the other defendants who did not file any appeal against that, there was no occasion for the court to set aside that finding. Isn't it? Since the other supporting defendants of the plaintiff,
They were not agreed.
they were not aggrieved, so there was no occasion for the learned first appellate court to set aside that finding with regard to Khata number 22. So that finding should have been sustained.
And apart from that, if the contesting defendants are agreeable so far as the 22 is concerned, there is no dispute with
They are not disputing.
the genealogy also.
No.
So in that view of the matter, there was no occasion for the learned appellate court to set aside finding with respect to Khata number 22. That's
That's
what I am
right.
saying.
That's right.
Yes.
Are you concerned with Khata number 22? Respondent, private respondent. I'm asking you. Are you concerned with Khata number 22?
Yes.
Yes means you are claiming a share in Khata number 22 also?
No, I'm not
Has
claiming.
the trial court given you any share in Khata number 22?
No, we are not claiming. No, that-
You are not claiming, so you are not concerned. Correct?
One third is living.
No, one third is not claiming. This
He
Bhikkhu,
denied total.
Bhikkhu Solar, you are representing the descendant, you are with respect to Khata number 33, your specific cases that Bhikkhu Sonkar was not the son of J.L. Mehta. Correct?
No.
And so far as Khata number 20, you are the dependent. Okay, you are Hulsa Mehta. You are the descendant of Hulsa Mehta. Contesting defendant are defendant number 3 to 6 or 3 and 6?
3 and 6.
3 and 6.
Yes.
Correct? Defendant number 3 and defendant number 6, that is Jainder Mehto and Thakuri.
Yes.
Correct? So they are the descendants of Hulsa Mehto. Correct? If they are descendants of Hulsa Mehto, then certainly they will be, since the property was jointly recorded in the name of
All the
Bikari, Hulsa and Nandu, therefore they are entitled through Hulsa Mehto to the extent of whatever share falls for them. Correct? When the learned trial court has decreed the suit in connection with the Khata number 22, you were not aggrieved by that. Were you? Did you file any appeal?
No, we have not filed the bill. Not that is the land belongs to the Khata number 33. Not that is
33 का
separate.
कहाँ नहीं है अभी 22 में है 22 we are talking about 22. The contesting defendant did not file any appeal against that?
In the lands belong to the khata number 20, that is separate kabjawari.
Was that your plea that there was this previous partition? Did you take a plea that there was a previous partition?
But judgment was there is no previous partition.
There is no plea of previous partition. How the appellate court has come to a finding that there was a previous partition? In absence of any such plea?
So far land belongs to the khata number 22. That is the joint family property. So far land belongs to the khata number 33. That is a separate property.
That's it. 33 is a separate property. We keep it separate. I'm asking you some questions regarding khata number 20. The trial court has directed partition of khata number 22 also. Correct? Now, so far as khata number 22 is concerned, was it your plea that this particular property, there, with respect to this particular property, there was a previous partition?
That has not come along.
So, in absence of any such plea that there was a previous partition, how the court would have come to a conclusion that there was a previous partition?
So far the land previous partition, they are claiming that there is a previous partition.
Who are claiming? Who is claiming that there was a previous partition?
Plaintiff will claim.
Plaintiff has claimed that there was a previous partition. Plaintiff has filed a partition suit.
Not for
They
the-
will not claim
for
that
the
there was a
partition.
previous partition. You are representing defendant number 3 and 6.
Yes, madam.
When you are representing defendant number 3 and 6, in your written statement, have you taken a plea that there was a previous partition?
Actually, learned trial court in order in option part, page number 49.
Page number 49.
Yes, Your Worship. It is ordered and decreed that the plaintiff have been successfully in proving their case of partition over total Schedule A property, and it is accordingly ordered that the suit is decreed for a partition in favor of plaintiff to the extent of their 1/3 share in the landed property of Schedule A, which contains item number 1. What is item number 1? Lord? Lands of Khata number 33 of village Mandarpela, police station Bahari Thana section Bahari District. Total 38 plots, area 6.5 acres. That is Schedule A property. Item number 1, Your Worship. With regard to Khata number 33, in the very next page, Your Worship, at page number 50, internal page 8,
Yes.
and 2, both more fully described in Schedule A, it is also ordered that survey knowing Peter Commissioner may be appointed at the behest of the plaintiff to carve out their share out of total property of item number 1 and 2 of Schedule A, and to make separate takta of plaintiff for preparation of final decree, and also for giving the version of the same through the process of court if so requires.
So there was a partition only in connection with khata number 33.
Yes, Your Worship.
पार्टीशन सिर्फ खाता नंबर 33 का हुआ मिस्टर शर्मा, खाता नंबर 22 का पार्टीशन नहीं हुआ। Schedule A property is only खाता number सिर्फ खाता नंबर 33 का पार्टीशन, 22 का नहीं पार्टीशन।
ये वन इंटू दोनों तो है, इसमें कोई दिक्कत नहीं। Judgment that for a 20. It is accordingly ordered that the suit is decreed for a partition in favor of the plaintiff to the extent of 1/3 share in the landed property of Schedule A, which contains item number 1 and 2. Both. More fully described in Schedule A. It is also ordered that a survey number Predator Commission may be appointed at the behest of the plaintiff to carve out their share to total property of item number 1 and 2 of Schedule A. is made separate kafta of the plaintiff for position of final degree and also for giving position of the same to the processor. Degree भी important है. Item number 1 में land of खाता number 33 है. Item number 2 में तो लिखा हुआ है तो item number 22.
Then why in the appellate court decree it is written? in the
इसमें
trial court?
ट्रायल कोर्ट का हम दिखा रहे हैं. ट्रायल कोर्ट का शेड्यूल जहाँ
कौन सा पेज नंबर बताए थे?
पेज नंबर 49, पेज 49.
पेज 40.
शेड्यूल ए में आउटलाइंस ऑफ खाता नंबर 33 और बांदरबेला पुलिस सर्जन से टोटल 38 प्लॉट्स 6.50. आइटम नंबर 2 खाता नंबर 22 और विलेज गुनाईपुर डिस्ट्रिक्ट सर्जन से टोटल एरिया 10.3. दोनों तो दिया हुआ है.
तो ये 49 में क्या लिखा है?
49 पे
पेज 49.
वो भी उसी को लिख रहा है.
नहीं 49 में देखिए ना ऊपर क्या लिखा है?
क्या लिखा है?
उनको दिखाइए कौन सा?
It is ordered and decreed that the plaintiff have. वहाँ पर
हाँ, it is ordered and decreed that the plaintiff have been successful in proving their case.
Total schedule A property.
Over, आगे बढ़िए ना बीच में.
And it is accordingly ordered that the suit is decreed for partition in favor of the plaintiff to the extent of share in schedule A which contains item number 1.
Item number 1. Item number is.
Item number 1.
Item number 1.
Item number 1 is only
खाता number 33.
खाता number 33.
लेकिन इसमें schedule इसमें पूरा में तो लिख रहा है तो बाद में इसको उतना ही नहीं आगे भी पढ़े. As per the Khatiyam. And item number 2, both fully described in schedule A, it is ordered that the Serving Commissioner be appointed as the behest of the carved out total property of item.
कॉन्फ्लिक्ट है ना, जजमेंट से दिख रही है.
जजमेंट है, डिग्री पढ़.
नहीं डिग्री में तो कॉन्फ्लिक्ट.
नहीं डिग्री पे आगे पढ़, आधा पढ़.
आगे तो पढ़ ले, लेकिन ये जो इट इज ऑर्डर्ड जो लिखा हुआ है, इट इज ओनली कंडीशन.
भी तो ऑर्डर ही. आगे फर्दर पढ़ा जाए इसको देखा जाए.
अब जजमेंट से दिखा.
जजमेंट से भी दिखा, डिग्री से भी पहले दिखा लेते हैं फिर जजमेंट पर आता है. यहाँ पर ये आइटम 1 लिखे, उसके बाद एक शेड्यूल का डिस्क्रिप्शन बता रहे हैं, उसके बाद फिर आगे इसमें देखा जाए. अच्छा हाँ, वो एक्चुअल में ओवरलैप कर गया. आइटम नंबर 1 के बाद यहाँ आइटम नंबर 2 आ गया. सेकंड पेज में
आइटम नंबर 1
वहाँ आइटम नंबर 1 लिखा गया, उसके बाद शेड्यूल दे दिए और शेड्यूल के बाद वहाँ उसके बाद नेक्स्ट पेज में स्टार्ट हो रहा है एड आइटम नंबर. ओवरलैप है. वही ठीक. एंड आइटम नंबर 2 भी तो लिखा हुआ है. वो वाला वहां तक आइटम नंबर 1 के बाद यहाँ पर ये इसको मिला कर और इसमें तो क्लियर है तो हम ऑर्डर पढ़ेंगे उसमें कोई डाउट.
इसमें जो 1/3 शेयर और मार्क किया है 1/3 शेयर बाय the trial court.
दोनों
Respect to schedule A and schedule
दोनों
schedule 1 and schedule 2. So far as schedule 2 is concerned, according to you, there was no grievance
दो
with
के बाद
respect to schedule 2.
उसको भी सेटिस्फाइड करने के ऊपर वजह ही बता रहे हैं वो इनके प्लीडिंग्स में अपने को इस वजह पर उस पार्ट में तो इनका जजमेंट पहले डिग्री बनाने बोले हैं उसके बाद फिर बोले हैं कि जैसा जैसा है वैसा करके and also for giving the position of the same through the process of the court. इसको सेटिस्फाइड करने का तो कोई कारण नहीं.
Jamni Devi was the applicant. Who is Jamni Devi? Jamni Devi.
जामिन
Who is she?
जामिन देवी वाइफ ऑफ मोटर महतो एंड डॉक्टर देवा महतो के हैं, गेंदर महतो के हैं, रूपन महतो के लोग हैं, कौशल्या देवी, दिव्या देवी, पद्मी देवी, they were all appellants. कोई कंटेस्टिंग नहीं है अपने. तो इन्होंने अपील किया उसका उन दोनों ऐसा नहीं है कि पार्ट अपील था, दोनों पार्ट का ही अपील. तो इनका पूरा अपील लाओ कर उस पार्ट से भी एग्रीड थे तभी ना. 33 से भी एग्रीड थे और 22 से भी एग्रीड। तो 33 पर तो कोर्ट ने इनका बात नहीं माना ट्रायल कोर्ट का, लेकिन 22 पर इनका जीनियोलॉजी भी नहीं डिस्प्यूट किया, लेकिन ये कह करके सेटिसाइड कर दिए कि सेपरेट है, सेपरेट डीलिंग है, कब्जेवारी सेपरेट है, प्रीवियस पार्टीशन में इस पॉइंट पर 22 पर तो इनका जजमेंट सस्टेनेबल है। बगैर जैसे 33 पर तो हमें जो बहस करना था हम लोग पहुंच गए। बाकी इनका स्टडी है काउंसिल फॉर द रिस्पोंडेंट बहस है।
पहले प्राइवेट रिस्पोंडेंट को सुनते हैं, फिर आप रिस्पोंडेंट। आप बताइए आपको क्या बोलना है? Yes, what do you have to say? You argue with respect to 33 and 22 separately.
So for judgment passed by the land appellate court, everything is discussed by the land appellate court.
Before we start from the one, I would like to give one thing. Otherwise, we will.
Which para are you citing? Which para?
The finding of the
Which paragraph are you citing?
Yes.
Para 15.
Separate place in possession and separate cultivation does not, among the co-partner, do not mean that there was a partition by which involved, or separation of one of the co-partner of the ancestral. Here the properties are not ancestral but self-employed. Thus, has directly held that any complaint against community to have no details of separation. Noting of Kabjawari in the review receipts reports do not prove separation of partition, which only gives an analogy that there was a separate cultivation or possession by the person in favor of whom Kabjawari.
And this is open about that there was no such pleading. There was no such pleading that there was a previous partition.
from the judgment below, that is page number 7, the finding of the court below,
Right court?
appellate court below.
Just a minute. Page number 7.
Yes, Lord. Just I am reading, Lord.
Yes.
The issue number 5, 4, 5 and 6. There is no dispute between the parties with regard to their ancestral lands situated in Khata number 22, village Donapur. Both the parties admitted that they are the separate position of the land of the same according to the convenience and the suitability. Even during the last cadastral survey, the settlement operation of the position of the ancestor of the plaintiff dependent have been recorded separately over the land Khata number 22 and village Donapur. The main dispute surrounded on the land Khata number 33 of the village Bandarmera. The plaintiff claimed that the recorded tenant of the said Khata, namely Gundia Sokariyar, was ancestor of the plaintiff and the defendant, and the lands also are joint co-custody property to which the both parties are entitled to equally share. The plaintiff had claimed that Gundia Sokariyar recorded tenant of Khata number 33 of the village Bandarmera. His son, Biko Sukariyar, whose father was Jharkhand, common ancestor of the both parties. According to the name, Bhikkhu Sukariyar was eldest son of Johan Naku. On the other hand, dependent number 3 and 6 claim that recorded till in Budya Sukariyar of his father Bhikkhu Sukariyar of village Bandar Villa was not from family of Jugal Mahto of village Doni Khurd. They had no concern with the said family and Jugal Mahto were not their common ancestor. Budya Sukariyar is recorded separately in the cadastral survey and the settlement of the operation of the land of Khata number 33 of village Bundia, Bandarvela. And none of the ancestors of the plaintiff or defendant have been recorded in the said Khata number Khata. In fact, after the death of the Bundia Sukariyar, his wife Musma was looked after the Rupan Mahto and Beni Mahto, ancestor of defendant number 3 and 6. Due to service rendered and satisfaction, Musma Somari executed the gift in favor of Rupan Mahto and Beni Mahto in 1944. She also sold the land of Khata number 33, the ancestor of the plaintiff, to others. Therefore, lands of Khata number 33 village Bundarvela is the joint Hindu Pasmi property of the plaintiff and defendant is not liable to partition. There is also dispute between the plaintiff and the defendant with regard to the date of death of Bundia Sukariyar and his wife Mokshma Somari. According to plaintiff, Bundia Sukariyar died in the 1935, while the wife of Somari, Mokshma Somari, is in 1944. Defendant number 3 and 6 have claimed that Bundia Sukariyar died either in the end of 1943, January 1944, while Muhammad Somri died in 1961. The finding of the case law, the learned counsel of the appellant have submitted that evidence recorded will go to show that Bundia Sukariyar and his wife Muhammad Somri were not of the family of the plaintiff and defendant, and they were not residing in the same house along with ancestors both the party. They were residing in the defendant village and the name of the Bundia Sukariyar is separately recorded in the land of Khata number 33 village Bandarvela. PW1 Baru Mahto is plaintiff number 1 of the case admitted in para 17 of that he lives in village Doni Khurd and had neither seen Bhikkhu Sukariyar nor his son Bundia Sukariyar. He claimed that he had seen Musma Somari and the village it was age 22 to 22 years at the time of death. Therefore, PW1 must have been born in 1936, which means that Somari died in 1958. This is the direct evidence given in the plaintiff with regard to the year of death Osman Somari in para 21 PW1 has further stated that he did not know that Bundia Sukariyar or Somari had sold the land during the lifetime. Although father of PW1 of the purchaser from the Osman Somari PW1 further pleaded ignorance in para 22 about the sale lands in chapter number 22 village Bonikur, whereas the plaintiff stated about the sale land of the sale lands by PW 14 about though in para 15 PW1 had challenged the deed of gift executed by Muslim Somari as for and fabricated. Documents relates they have been sought to set aside the said deed of the father, his father, and he is party to the purchase of the land. Musmat Somri PW2 Budhan Mato is para 10 has Rupan Mato and Behri Mato had got the lands of gift executed Musmat Somri in their favor in Khata number 33. This fact has been corroborated by DW1 defendant number 3 in para 20 of this that his father Rupan Mato no share in the land sold by Musmat Somri. In para 7 he admitted that he had no land of house at
हाँ
Bidin.
वैसे पूरा जजमेंट किससे पढ़े? Are you arguing your case? We have read 2 दिन से पूरा जजमेंट वर्ड बाय वर्ड पढ़ लिए. आप हमको बताइए what is your argument?
So argument for the land belongs to the Khata number 33 in Lord. That is the lands of gifted to them their separate land, and they are not ancestor of the land is not joint property.
Fine. 33 over. What about 20?
20 so far the land belongs to Khata number 22 Lord. That is the separate, that is property, that is joint property Lord, that has been partition has been made. So far this property Lord.
No, but that direction for partition has also been set aside by the appellate court. Is that so? The appellate court has set aside that finding also, that Khata number 22 will be partitioned.
That is the previous partition Lord.
There is a plea of previous partition. Which defendant has taken the plea of previous partition? Which defendant has taken the plea of previous partition? Tell us. Did defendant number 3 and 6 say that there was a previous partition? Rather, defendant number 3 and 6 is saying that in case of partition, they are also entitled to share. I have nothing to say so far as statement in para 9 of the plaintiff is concerned, but the plaintiffs are called upon to involve land of all other khatas, including land of khata number 22. In case of partition, these defendants are also entitled to a share. कहाँ है आपका? तो प्रीवियस पार्टीशन का कोई प्ली नहीं है तो क्या डिक्री हो जाएगा प्रीवियस पार्टीशन का? The non-contesting defendant had also said that they are entitled to 1/3 share.
Non-contesting defendant had not come forward to the.
That's right. Was that your case that there was a previous partition? है कहीं केस आपका प्रीवियस पार्टीशन का? तो फिर फाइंडिंग कैसे हो जाएगा प्रीवियस पार्टीशन? Merely because there is कब्जा बारी?
There is separate kabja bari and
That will not, that is, that has got nothing to do.
The Khatian is separate lot. CW1, exhibit C1 is there, C1.
Mister, unless there is a plea of previous partition, can a finding of previous partition be recorded without a plea? So the partition with respect to khata number 22 was not to be interfered. Some properties have also been sold in khata number 22, Mr. Sharma.
ऐसा तो कोई रीडिंग्स नहीं है इधर से,
ऐसा तो कुछ नहीं होता।
लेकिन ट्रायल कोर्ट में डिग्री यही है कि फाइनल डिग्री बना करके पोजीशन वगैरह भी करना।
With respect to 22 also.
22
Hi, Marcus, you tell us.
There is no play with regard to khata number 22. Is there the previous partition or something?
There is no such thing.
There is no such play at all. But the main issue with regard to khata number 33, and the crux of the issue is that whether the Bundia Sokyar or Budi Sokyar was the from the Jugal Mato family. That is the only issue. And from not a sheet of paper has been proved by the plaintiff that Bundia Sokyar or Budi Sokyar was the family member of the Jharkhand. While discussing the issue,
Yes.
while discussing the issue number 8, no documentary evidence has been taken by the learned trial. While discussing the issue number 8,
And the evidence of plaintiff has also not been considered.
no, nothing. Only oral submission by the evidence of the defendants was taken in
What
consideration.
about DW7?
DW7.
पैरा 8 में क्या पढ़ा था? पढ़िए थे, पढ़ाई में नहीं आ रहा। आप लोग जरा पढ़िए तो किसका किसका नाम बोला है वो?
इसका
ये चचेरे भाई।
DW7
हाँ। DW7 किसके किसके बारे में बोले हैं कि चचेरे?
भीखू महतो के पिता का नाम मैं नहीं जानता हूँ। यह सत्य नहीं है कि मैंने गलत बयान दिया है।
एक सेकंड, पैरा 7 में?
पैरा 7 पैरा 8 में।
DW7 पढ़िए तो ठीक से। PW7 का एविडेंस शुरू से पढ़िए, छोटा ही है।
दोनों पक्षों को मैं जानता हूँ। बांदर बेला एवं दोनाई मौजा का जमीन का झगड़ा है। बांदर बेला वाली जमीन का खतियान बूंदी महतो के नाम से है। बूंदी महतो को मैंने देखा था। बूंदी महतो भाई में अकेले थे। बूंदी महतो के पिता भी भाई में अकेले थे। बूंदी महतो के कोई बेटा नहीं है। बूंदी महतो की पत्नी का नाम सोमरी है। दोनों की मृत्यु हो पहले बूंदी महतो की मृत्यु हुई, बाद में सोमरी खेतीबाड़ी पर रूपन महतो के साथ थी। उसे 6.5 एकड़ जमीन बंदर बेला में सोमरी के 3 एकड़ डिसमिल जमीन रूपन महतो एवं बेनी महतो को दान पत्र द्वारा दे दी थी। शेष 2 एकड़ डिसमिल जमीन को सोमरी ने देवा महतो, बेनी महतो, चुटर महतो एवं नानो महतो को यहाँ बिक्री कर दी थी। खरीदार लोग अपने अपने खरीद की जमीन पर हैं। दान पत्र वाली जमीन पर भी लोग दखल है। सोमरी का बंदर बेला मौजा का कोई जमीन नहीं बचा। दोनों दुआई वाले जमीन के सभी हिस्सेदार अपने अपने हिस्से की जमीन में जो काम है। प्रतिपक्ष जेहल महतो का नाम मैंने सुना है। जेहल महतो का बेटा भिखारी महतो नहीं है। भिखारी महतो को भी मैंने नहीं देखा है।
एक सेकंड, पहले तो ये बोलते हैं जेहल महतो का बेटा भिखारी महतो नहीं।
अपने खिलाफ ही नहीं बोल रहे।
ठीक है, खिलाफ ही बोल रहे हैं, भिखारी महतो नहीं।
भिखारी मतलब हमारे फादर के बारे में।
हाँ ठीक है,
तो वो उसको भी
Just a moment, the dispute is in connection with Bhiko Sonkar.
विकास हो गया
Bhiko Sokia.
इनका भिखू का कहना भिखू तो बौद्धिक सौकर्याल के फादर के बारे में, लेकिन उसको नहीं कहा कि हमारे बारे में भी कह रहे हैं, ये भी कह रहे हैं विलास के बारे में
कह रहे हैं ना, तो फिर इसको रिलाई करके कैसे कोई फाइंडिंग रिकॉर्ड कर
इसको
सकता
फाइंडिंग
है?
नहीं दिया हम
The
देखेंगे
trial court has relied upon this. Sorry,
6 para 6 related
the para 6 selected paragraph थोड़ी पढ़ेंगे. एक पैराग्राफ पढ़ेंगे, दूसरा पैरा नहीं पढ़ेंगे.
नहीं ठीक
हाँ ठीक है, बताइए.
भिखारी महतो को मैंने नहीं देखा है. जेहल महतो को 3 लड़का, उल्लास महतो का लड़का था या नहीं वह भी मैं नहीं बता सकता हूँ. उल्लास महतो को मैंने नहीं देखा, नानू महतो व जेहल महतो को भी मैंने नहीं देखा. मतलब तीनों बेटा को नहीं देखा.
तीनों बेटा को नहीं
तीनों बेटा को नहीं देखा. भीखू महतो को भी मैंने नहीं देखा है. भीखू महतो का नाम मैंने सुना है. भीखू महतो बेटा जेहल महतो का नहीं था.
इनका जो लड़का है जो इनका डिफेंडेंट
पैरा नंबर 3 लास्ट पैरा
in cross examination.
इन क्रॉस एग्जामिनेशन भीखू महतो बेटा जेहल महतो का नहीं था.
जो एक्चुअल में लाइव बेटा
एक सेकंड सर, प्लीज आपको सुने ना, 2 दिन पूरा सुने, आप उनको डिस्टर्ब नहीं करें.
बूंदी महतो को देखने का समय मेरा उम्र करीब 15 वर्ष था. उस समय बूंदी महतो की मृत्यु हो गई थी. दुनिया सोकिया बूंदी महतो की मृत्यु के साथ उनकी पत्नी सोमड़ी जीवित थी. उनकी लड़की हिमनी देवी की मृत्यु पिता की मृत्यु के 1-1.5 वर्ष के बाद हुआ था. हिमनी के मरने के बाद करीब 10-11 साल के बाद उसकी मां सोमड़ी की मृत्यु हुई 1935-1944. बूंदी महतो एवं उनकी पत्नी सोमड़ी की मृत्यु के बाद बंदर बेला वाली मकान में रूपन महतो वगैरह रहने लगे. बूंदी महतो एवं उनकी पत्नी की मृत्यु के बाद बंदर बेला एवं दोनाई मौजा उनकी जमीन को रूपन महतो वगैरह जोतने लगे. चूटर महतो, देवा महतो,
एक सेकंड, चूटर महतो, रुक जाइए, इस नाम को पूछने दीजिए. काम
चूटर महतो
इसमें तो चूटन महतो का तो इसका कहीं नाम ही नहीं है. पूरा जिनोलॉजी में चूटन महतो का ये चूटर है.
चूटर.
ओके ठीक है. इसका नाम लिया है
बेनी महतो.
चूटर का नाम लिया है बेनी.
एक और कोई नाम मुझे पता नहीं है.
बेनी का नाम लिया है. ओके आगे.
बैजू महतो.
बैजू. Just a minute. बैजू. बैजू बोल के तो इसमें कहीं किसी का नाम नहीं है. ठीक है. बादू है, BADU.
बैजू.
बैजू.
इलियस
बैजू होगा.
इलियस भाजू है. इलियस भाजू महतो.
यही होगा बैजू.
सोमा महतो.
सोमा. सोमा का भी जिनोलॉजी में कहीं नाम नहीं है. नॉट देयर.
नाम मुझे पढ़ना नहीं जा रहा है. सम वो महतो के चिंटू या सम महतो. दीना महतो.
दीना महतो का भी इसमें कहीं नाम नहीं है. देवा महतो.
दीना है.
भीखू सोनकार या भीखू महतो भी नहीं बोला है. भीखू महतो का नाम कहाँ है?
इसमें कहीं उनको महतो सभी आपस में चचेरे भाई हैं. मेरे सामने में उन लोगों के बीच आपस में कभी बंटवारा नहीं हुआ. खाता नंबर 33 एवं 22 की जमीन के सभी जमीन से नहीं है. कहीं से भी सरोकार नहीं है. खाता नंबर 22 की जमीन मुझे कहीं से भी सरोकार नहीं है. दान पत्र एवं
मेरे सामने नहीं हुआ था। आखिरी में बोलता है कि भीगो महतो के पिता का नाम मैंने
भीखू महतो को तो पैरा 7 में नहीं बोला है नाम, पैरा 6 में देखिए तो
पैरा 6 में भी नहीं है।
पढ़िए तो एक बार ठीक से।
खाता नंबर 33 एवं 22 की जमीन मुझे कभी कहीं से भी सरकार नहीं है, दान पत्र एवं मेरे सामने में नहीं हुआ था।
यही है पैरा 6।
पैरा 6 ही है। पैरा 6 ही है।
ट्रायल कोर्ट ने पैरा 6 तो रिलाई किया है ना।
शूटर मत ये तो पैरा 5 है।
6 हिंदी में
अच्छा अच्छा, हिंदी और इंग्लिश दोनों मिला कर
बताइए।
बस चूटर महतो, देवा महतो, महतो, सुधा महतो,
बेनी महतो,
बेबी महतो, बैजू महतो, इलियस भजू महतो, सोमा महतो, शिपू महतो, दीना महतो एवं मुंगीर महतो, सब डिंगुल महतो, सभी आपस में चचेरे भाई हैं। मेरे सामने
ये
में
भीखू महतो का तो नाम नहीं है।
भीखू महतो का नाम नहीं पता।
नहीं है ना?
नहीं।
ना ट्रायल कोर्ट ने भीखू महतो कैसे लिख दिया? भीखू महतो इज नॉट देयर।
भीखू तो है। भीखू भीखू
भीखू
भीखू भीखू क्या है?
सोमा महतो के बाद भीखू महतो।
हम फॉर्म ऑफ डिपोजिशन ही पढ़ रहे हैं।
भीखू मातो
ये 7 का भीखू महतो नहीं है यहाँ।
सोना के बाद भीखू मातो कैसे लिखा है? पढ़िए ना ठीक से इसको। भीखू मातो पे लिखा है। कैसे आप पढ़ रहे हैं? हमारे पास भी तो सर्टिफाइड होते हैं।
जो ये भीखू महतो ये
भीखू मातो ही है।
ये एक्चुअली पढ़ा नहीं रहे इसमें क्या है।
अच्छा
इनके पास जो है उसमें पढ़ ले रहे हैं।
टाइप कॉपी है क्या? सर्टिफाइड का
नहीं ये तो सर्टिफाइड था, हमको देख वो तो टाइप लग रहा है, सर्टिफाइड अलग है।
हम तो भीखू पढ़ रहे हैं, कैसे नहीं पढ़ पा रहे हैं?
हम तो नहीं पढ़ पा रहे
साफ सुथरा भीखू है।
इसमें नहीं।
है सब ठीक से पढ़ रहे हैं। सोना के बाद क्लियर भीखू है।
ये जेहल महतो के 3 लड़के के ही बारे में बोल रहा है पैरा 3 में। चौथा लड़के के बारे में नहीं
ये वो ठीक है। तो ये भी कह दिए कि हुलास भी नहीं है,
हाँ,
देवा भी
तो
नहीं है।
इसके एविडेंस का क्या ही रेलेवेंस?
इसी का एविडेंस तो अपील कोर्ट भी तो
नहीं अपील कोर्ट लिखा है लेकिन बहुत रिलाई नहीं।
इसी तरह का सारा एविडेंस ही है। CW1 का एविडेंस है।
ये खाता नंबर 22 में आपको क्या व्हाट डू यू हैव टू से टू खाता नंबर 20?
खाता नंबर 22 का जहाँ तक मैटर है, डिफरेंट बोथ द पार्टीज फ्रॉम द सेम फैमिली, अगर उनका पार्टीशन होता है तो भी उन्हीं को जाएगा, नहीं भी होता है अगर सेटिस्फाइड भी हो जाता है
तो
वापस
भी उन्हीं को
तो भी उन्हीं को हो जाएगा, उसमें कहीं भी कोई डिस्प्यूट नहीं है।
But there is no plea of previous partition.
There is no plea of previous partition in
So
the
the land and trial court, the appellate court has wrongly held that.
Wrongly
there was
held
a-
that it is
That was beyond the
that is wrong.
And that was one of the reasons to set aside the trial court judgment with respect to खाता number 20.
Only with respect to खाता number
खाता number 20. तो 33 में तो कुछ है ही नहीं.
33 nothing. और ट्रायल कोर्ट जो प्रिज्यूम करते हैं पेज 15 अगर उसमें देखा गया इंटरनल पेज 15 of the judgment of the so from the first line so with regard to the landed property of khata number 33 a strong presumption is raised in favor of the plaintiff that the property was the co-passionate property and now the burden lies on the contesting defendants to prove that the property of khata number 33 of Bandapella was a separate property of Bhulian. Only on the basis of presumption.
Better.
और एक चीज से हम दिखाना चाहेंगे
हाँ.
पेस्ट इन इंटरनल पेस्ट इन ऑफ एप्लेट रिपोर्ट from the line 11th line.
Please.
DT.3 further statement admitted in para 12 that he came to know from his father and elderly people of the village that Hiko Sokyar was son of Jharkhand. This evidence is hearsay evidence. PWP had not seen either Bhiko Mato or Bhulia Sokyar. However, in para 13, he admitted that ancestor of the plaintiffs and defendants, namely Visari Mato, Ulas Mato, Nanu Mato, had no share in the lands of Khata number 33, and Bhiko Mato was not of the family of Jehal Mato. This is the PW3.
Their own witness.
Yes, their own.
If you heard the learned counsel appearing on behalf of the parties. एकदम आराम से लिखिए, ठीक है? This appeal has been filed against the judgment dated 18/10/2004 within bracket decree dated 23/11/2004 brackets passed by the District Judge Hazaribagh entitled Appeal number 20 of 2004 arising out of judgment and decree dated 30/4/2004 passed in partition suit number 82 of 1997. The learned trial court had decreed the suit with respect to item number 1 relating to khata number 33 and item number 2 relating to khata number 22 of the Schedule A property and directed that the plaintiffs would be entitled to 1/3 share with respect to the Schedule A property. With respect to each item of Schedule A property.
Properties are of different villages. One is of Bandarpel,
Just-
another is of Sonipur.
Item number 1 of Schedule A property is of village Bandarbela and item number 2 of Schedule A property is of village,
Donai
how do you spell it?
Donai, D-O-N-A-I.
D-O-N-A-I.
D for that.
D-O-N-A-I.
K-U-R-D.
K-U-R-D.
K-H-U-R-D.
ऐसे है स्पेलिंग इसका D-O-N-A-I-K-H-U-R-D. The learned trial court decreed the suit and the learned first appellate court has set aside the judgment and decree with respect to both item number 1 and item number 2 of Schedule A, and consequently the contesting defendant, that is the plaintiffs are the appellant, and consequently the plaintiffs are the appellant before this court. This appeal was admitted for final hearing by order dated 26/6/2009 on the following substantial question of law, inverted comma, whether the learned lower appellate court has correctly met with the findings of the trial court by reversing the same, inverted comma clause. The learned counsel for the appellant, by referring to the trial court judgment, has submitted that the issues which were, amongst the issues which were claimed by the learned trial court, issue number 5, 7 and 8 are most relevant issues. We have submitted that issue numbers 7 and 8 are primarily related to Khata number 33, and so far as issue number 5 is concerned, it relates both to Khata number 33 and Khata number 22. The learned counsel submits that the specific case of the plaintiff was that Jehal Mehto had 4 sons, namely Bhiku, B-H-I-K-H-O, Sonikar, S-O-N-I-K-A-R, Bhikari Mehto, B-H-I-K-H-A-R-I, Mehto, Hulsa Mehto, H-U-L-A-S-H Mehto, and Nanhu Mehto, N-A-N-H-U Mehto, and the property with respect to Khata number 33 was exclusively recorded in the name of Bhiku Sonkar. Okay, अभी ये last sentence. He submits that Bhiku Sonkar had a son named Budia Sonkar.
Both.
B-U-N-D-I. Sonikar, and his wife was Mausamar Somri, who had a daughter named Hemia Devi, who predeceased her mother. Consequently, ultimately, Mausamar Somri died issueless. He submits that the property with respect to Khata number 33 was recorded in the name of Bundia Sonkar.
Sokia.
B-U-N-D-I-A-S-O-K-I-A-R. And upon the and consequently, the property with respect to Khata number 33 devolved upon the 3 branches of Jehal Mehto, who were the agnates of Bhiku Sonkar.
Jehal.
Who were the agnates of Bhiku Sokia. The learned counsel has further submitted that the contesting defendant had disputed the genealogy, and according to them, Bhiku Sokia was not the son of Jehal, and they were claiming the property by virtue of gift deed / sale deed executed by Mausamar Somri, which were duly registered. The learned counsel further submits that so far as the property in Khata number 22 is concerned, the same was admittedly so far as Khata number 22 is concerned, it did not have the name of Bhikkhu Sukhiyar, but it was recorded in the name of Bhikari Mehto, Ulas Mehto and Nanhu Mehto / their descendants. He submits that since the plaintiffs claimed that entire property, that is Khata number 33 and Khata number 22, belonged to the joint family, therefore,
Yeah.
the joint family of Jehel Mehto, therefore, they claimed partition with respect to the entire property. However, both the courts have dealt with the property of Khata number 33 and Khata number 22 in different paragraphs. By referring to the judgment of the learned trial court, the learned court submits that with respect to Khata number 33, issue number 8 was the most important issue. And if issue number 8 is decided in favor of the plaintiff, then naturally the plaintiffs would be entitled to a share in Khata number 33. He has referred to the findings recorded by the learned trial court with respect to issue number 33 and has submitted that the learned trial court has considered the fact that the defendant number 3 and 6, who were the contesting defendant, had not specifically mentioned the name of the father of Bhikkhu Sokyaka. And the denial in the written statement was evasive. The court has taken, apart from this aspect of the matter, the court has also considered the evidence of the oral and documentary evidence of the defendants, including the evidence of DW7, DW3 तो आपने प्लेस किया, including the evidence, all the evidences of सभी का consider किया, 3 का 4 का has considered the evidence of the defense, the DWs, including the evidence of DW7, to come to a finding that Bhikkhu Sokyar belonged to the family of Jehel Mehto and ultimately directed for partition of the property in Khata number 33. So far as Khata number 22 is concerned, the council further submits that with respect to, by deciding issue number 7, the learned appellate court recorded that there was no averment in the written statement to the effect as to how and in what manner the property was separately acquired and possessed by Budhiya Sokiyar and ultimately which was in turn sold / gifted by his wife Mausamat Somji upon death of Budhiya Sokiyar, and ultimately the court held that the property in Khata number 33 was joint family property, joint co-custody property of J.L. Mehto and others, and directed for partition of the same. The learned counsel further submits that so far as issue number 5 is concerned, 22 का अलग से consideration नहीं है. So far as the Khata number 22 is concerned, the learned trial court observed in paragraph 19, in continuation of the finding of jointness with respect to Khata number 33, the Khata number 22 of item number 2 of Schedule A property, it was not in dispute from the pleadings of the parties and during the course of argument before the learned trial court that this property is subject of partition amongst the parties. And while considering issue number 5 and 6 together, the learned trial court in paragraph 20 of the judgment ultimately directed for partition of 1/3 share with respect to item number 1 and 2 of Schedule A property, covering Khata number 32 and 33. During the course of argument and upon a query of this court, it is not in dispute from the side of the learned counsel for the appellant that the learned trial court, by considering the finding with respect to issue number 8, has not at all considered any of the evidence, oral evidence of the plaintiff. And the finding is primarily based on the finding only discusses the oral evidence of the defendants. Sorry?
Oral and documentary.
Oral and documentary evidence of the defendants. The learned counsel has then referred to the judgment passed by the learned first appellate court and has submitted that the learned first appellate court has reversed the finding in connection with the learned first appellate court has also considered all the issues as framed by the learned trial court and has taken same issues है दोनों का same नहीं there are 9 issues, this is 7. Has framed the following issues for consideration. Para 14. And the learned first appellate court has reversed the finding of the learned trial court with respect to relationship of J.L. Mehto and Biko Sokiar and consequently has held that the property of recorded in the name of Budhiya Sokiar, son of Biko Sokiar, could not be subject matter of partition the learned counsel has submitted that the learned first appellate court has failed to consider the fact that the defendant in the written statement had not disclosed the father's name of Biko Sokiar and the learned first appellate court has also not properly considered Exhibit B and C and further the evidence of DW1 and DW7 has also not been properly considered. It submits that the evidence of DW1 and DW7 was duly relied upon by the learned trial court to record a finding. The learned counsel submits that the learned first appellate court has not met with the reasons assigned by the learned trial court by reversing the findings in connection with Khata number 33 and also with respect to relationship of J.L. Mehto and Biko Sokiar. The counsel submits that hence the judgment passed by the learned first appellate court.
With respect to Khata number 22.
22 का भी आ रहा है. With respect to Khata number 22, the learned counsel for the appellant has submitted that irrespective of the findings in connection with Khata number 33, there was no dispute that Khata number 22 could be subject matter of partition. He has submitted that the property in Khata number 22 was admittedly recorded in the name of family members of J.L. Mehto so far as they related to Nikari Mehto, Udas Mehto, Nani Mehto / their descendants. He has submitted that it was never the case of any of the dependents before the court that there was a previous partition with respect to Khata number 22. The learned counsel submits that in absence of any such plea having been taken in the written statement, it was not open to the learned first appellate court to come to a finding of previous partition based on separate kabjibara / possession of one or the other family member of the joint family consisting of J.L. Mehto and his descendants. The learned counsel has also relied upon the judgment passed by Honorable Patna High Court, reported in 1998 SSC Online Patna 517, paragraph 15, paragraph 14.
Separate any mess division.
To submit that separate in mess and separate cultivation amongst co-sharers does not mean that there was partition by meets and bound or separation of one of the co-partners from the ancestral property.
Next line is nothing of the very next page.
He has also and that noting of Kabjawadi in revenue record does not prove separation of partition, which only gives analogy that there was separate cultivation or possession by persons in whose favor Kabjawadi has been recorded. The learned counsel submits that on the one hand, there was no plea of previous partition, and on the other hand, primarily the finding has been recorded by the learned first appellate court on the basis of Kabjawadi. He submits that such an approach of the learned first appellate court while dealing with Khata number 22 is perverse and false for interference. The learned counsel submits that even assuming, though not admitting, that the plaintiff did not have any case in connection with Khata number 33, but there was no occasion for the learned first appellate court to interfere with the finding in connection with Khata number 22. The learned counsel submits that had the legal position been correctly taken into consideration by the learned first appellate court, in the light of the pleadings of the parties, there was no the learned first appellate court could not have set aside the finding of the learned trial court with respect to partition of Khata number 20. That is all. The learned counsel for the respondent, contesting respondent, contesting है ना 3 and 6. The learned counsel for the contesting respondent number 3 and 6 has vehemently opposed the prayer of the appellant by addressing this court on the with respect to Khata number 33 and the relationship of Deepu Sokia and J.L. Mehto. The learned counsel has submitted that the learned trial court has wrongly put the burden, has wrongly appreciated the written statement, and it was for the plaintiff to prove the genealogy who claimed to be who claimed that Deepu Sokia was their family member. He has submitted that the learned trial court has not even considered the oral evidences of the plaintiff by coming to the finding. He has also submitted that even the learned first appellate court has considered all the evidences on record, both oral and documentary, and all the of both the parties, by setting aside the finding of the learned trial court with regard to relationship of J.L. Mehto and Deepu Sokia, and also rightly set aside the finding in connection with Khata number 33 as the property in Khata number 33 was exclusively recorded in the name of Budhya Sukhiyar, son of Bhikkhu Sukhiyar. He has also submitted that the properties of Budhya Sukhiyar was ultimately sold by his wife through gift deed, was ultimately transferred by his wife through gift deed / sale deed in favor of the contesting dependent by registered deed, and those deeds were also not under challenge at any point. He has submitted that so far as the finding in connection with Khata number 33 and the relationship and the finding that Bhikkhu Mehto and accordingly his son Bhikkhu Sokia and his son Budhya Sokia did not belong to the family of Jain Mehto, do not borrow any details. With respect to the evidence of DW7, the learned counsel submits that the evidence has to be read as a whole, and the paragraph 7, the paragraph 6, and the witness DW and the evidence of DW7 reveals that he has categorically stated that Budhya Sokia was that Bhikkhu Sokia and accordingly his son Budhya Sokia did not belong to the family of Jain. In cross-examination in paragraph 3, this witness has also stated that Bhikari Mehto was not the son of Jail Mehto, although it was nobody's case that Bhikari Mehto was not the son of Jail Mehto. Yes, further कहाँ लिखा हमने 3 बेटे थे? He has also stated in paragraph 3 itself that in cross-examination that Jail Mehto had only 3 sons. And it cannot be said that this witness had supported the case of the plaintiff in any manner. And this witness had never seen any of the sons of Jehoram, the so-called common ancestor. The learned counsel has also referred to the evidence of DW1, who in his cross-examination, admit किया ना cross-examination में DW1, yes, Amicus? Yes. Who in his evidence कौन सा paragraph बताया
PW3, internal page 10 of appellate.
PW3,
Yes, appellate court judgment.
he has referred to the evidence of PW3 as recorded by the learned first appellate court at page number
10, internal page 10.
as internal page 10 of the appellate court's judgment.
11th line.
11th line, that in para 13 he admitted that Vikari Mehto, Hulas Mehto and Nanbu Mehto had no share in the land of Khata number 33, and Biko Mehto was not of the family of Jehel Mehto. The learned counsel has submitted that the first appellate court has done the needful and considered all the materials on record to come to definite finding that Bhikkhu Sokiar and consequently his son Bundia Sokiar, within bracket the recorded tenant of Khata number 33 bracket close, did not belong to the family of Jehel Mehto, and consequently Khata number 33 could not be subject matter of partition. With respect to Khata number 22, the learned counsel for the respondent as well as the learned amicus have the learned counsel for the respondent has not been able to point out any statement made in the written statement stating which could indicate that any stand was taken by the defendants, by the contesting defendant in particular, or the other defendants about any previous partition. However, he has submitted that the learned first appellate court has taken into consideration of the different kabja body and has come to a finding of previous partition. He submits that the learned first appellate court has rightly set aside the decree of partition in connection with खाता number 22 also. यही बोल सकते हैं, इसके अलावा तो कुछ नहीं. The learned amicus has submitted that so far as खाता number 33 is concerned, he has nothing to add over and above whatever has been stated, whatever has been submitted by the learned counsel for the private respondent, private contesting respondent. Correct? इसके अलावा तो कुछ नहीं बोलना. So far as the judgment in connection with खाता number 22 is concerned, the learned counsel, the learned amicus has submitted that in absence of any plea regarding previous partition, there was no occasion for the learned first appellate court to record a finding to that effect. He has also not been able to distinguish the judgment passed by the Honorable Patna High Court, which has been relied upon the learned counsel for the appellant. That's all. Findings. Partition suit number 82 of 97 was filed claiming that the plaintiffs and the defendants are members of Upasamiti of Hindu joint family and descendants of common ancestor namely Jehal Mehta, who died before the last cadastral survey operation, leaving behind three sons, Bhikari Mehta, Vilas Mehta, and Nanhu Mehta, and a grandson, namely Bundeo Sokia, son of Bhiko Sokia, the predeceased son of Jeremy. The genealogy has been annexed to the plate. It was their further case that Jehal Mehta was owner of the property in Khata number 33, consisting of 38 plots, area 6.50 acres, which came to be recorded in the name of India Sokia, son of Sokia, and was described in item 1 of Schedule A of the plate. And further, he was also the owner of 10.38 acres of land consisting of 31 plots. Recorded in Khata number 22 in the joint name of Bhikari Mehta, Vilas Mehta, and Nanhu Mehta, sons of Jehal Mehta having equal share, which was item number 2 of Schedule 8. It was their further case that Budhia Sokyar, the recorded tenant of Khata number 33, died in a state of jointness, which is with his uncles, cousin brothers, uncles and cousin brothers, and sometimes in the year 1935, leaving behind his wife Montama's Sundri, who also died sometimes in the year 1954 without any male issue, and consequently, upon her death, the entire property devolved upon the remaining three sons of Jehal Mehta, namely Bhikari Mehta, Hulsa Mehta, and Nanhu Mehta. With respect to Khata number 22, the specific case was that the same was joint family property and the interest property recorded in the name of Bhikari Mehta though recorded in the name of Bikari Metro in that was joint family property, and consequently the same was also subject matter of partition. The plaint describes the various family members and their date/year of death. It was asserted in the plaint that there has never been any partition amongst the recorded tenants either by means and bound, but they were in separate possession of some of the plots of Khata number 22 according to their suitability and convenience, and which were recorded in their separate Kabjawadi entry. But major portion of Khata number 22 was recorded as Ijmal, IZMAL. And the parties were in joint possession of the land of Khata number 22. It was also asserted that Deva Mento, one of the members of the family, had transferred 1.15, 1/3 acres of land out of total area of Khata number 22 in favor of his son, Haro Mehto, defend number 14. Son-in-law, Haro Mehto, defend number 14, husband of DILI. And the said area was deducted from Jamabandi of Khata number 22 and was running in the name of Tutor CHUTTAR Mehto and others. It was also asserted that besides the Khata number 22, the land of Khata number 33 devolved upon the parties. The plaintiffs demanded partition, and ultimately when the defendants refused, the suit was filed seeking partition. The defendant number 3 and 6 were the contesting defendants. Who clearly asserted that Budhia Sokiar was not the descendant of Jehal Mehta. And that defendant number 3 had acquired a portion of the property measuring 3.90 acres in gift from Mausamad Somdi, wife of Budhia Sokiar, which could not be subject matter of partition. it was also asserted that Nanu Mehto and Tutan Mehto also purchased land in Khata number 33 from Mosamad Somri and acquired right, title and possession. With respect to such property. It was categorically denied that Nikos Sokiar or his son Vidya Sokiar or Mosamad Somri were ever co-partner of undivided Hindu joint family of the descendants of Jehal Mehto, and that, as a matter of fact, Nikos Sokiar was not the son of Jehal. It was asserted that Mosamad Somri died sometimes in the year 1961 and not in the year 1954. The specific case of the contesting dependent was that after death of Budhiya Sokiar, his widow Mosamad Somri used to be maintained by Rupan Mehto and Devi Mehto, sons of Ullas Mehto, whom Budhiya had adopted as brother by customary Sahya relationship. And that Rupan Mehto and Beni Mehto had helped Mosamad Somri economically in performing the shraddh of her late husband, Budhiya Sokiar, and performed the shraddh of Somri on her death. On 18/4/1944, the gift deed was made by a registered deed dated 19/4/1944, and the sale deed was made on 18/4/1944, again by registered sale deed, both by Mosamad Somri, with respect to property in Khata number 33. Gift was for 3.90 acres and the sale was for 2.68 acres. It was also asserted that in case of partition, the contesting dependent would also be entitled to share of their rights with respect to Khata number 22. From the perusal of the written statement of the contesting dependent, that is dependent number 3 and 6 within bracket, Jendar Mehto and Thakuri Mehto, it is clear that at no point that no such plea was raised that there was in previous partition with respect to the suit property. A different written statement was filed by the dependent number 8 to 13. 10 to 13. In their written statement also, no such plea of previous partition was raised. Rather, they were supporting the case of the plaintiffs. So far as other defendants are concerned, the proceeding was expanded. Both the parties led joint and oral and documentary evidences before the court. The learned trial court framed the following issues for consideration. For the purposes of the present case, issue number 5, 7 and 8, as pointed out by the learned counsel for the appellant, are relevant. So far as the finding of issue number 8 is concerned, this court finds that the learned trial court has referred to the plaint and the written statement and has recorded that the contesting defendant number 3 and 6 had not suggested as to who was the father of Bhiku Sukyar. And observe that the written statement of defendant number 3 and 6 was evasive, and there was an active concealment with respect to the name of the father of Bhiku Sukyar. And the plaintiffs had categorically stated that J.L. Mehto was the father of Bhiku Sukyar. The court observed that evasive denial and active concealment is fatal in civil proceedings, and same would be taken as admission. The court further observed that the witnesses of the contesting defendant have also very cleverly made silence and also made denial with respect to the fact as to who was the father of Bhiku Mehto. Though the witnesses were of advanced age ranging from 65 to 75 years and of the same village where Khata number 33 was situated. Thereafter, the learned trial court has discussed the evidence of the dependent witnesses, and observed that DW1, Gender Mehto, the contesting defendant himself, has stated in para 11 that he was the person who performed the Shraddha ceremony of Soti, wife of Budhiya Sukyar, and at that time he was aged around 15 to 20 years. And in order to meet the expenses of Shraddha ceremony, his father Rupan Mehto and Deva, son of Chutar Mehto, had sold 8 dismal of land of Khata number 33, and observed that it means that the sale was referable to, the court observed that the sale was referable to land of Somri, which is item number 1 of Schedule A. The court then observed that it meant that there was a relationship of co-custody between DW1 and the recorded rayat of the Khata number 33, the husband of Mosamad Somri, that is Budhiya Sukyar. Thereafter, the learned court considered the evidence of DW7 by stating that there is a startling evidence of this witness, who is a senior citizen of 70 years of age and belonging to the same village, and that in paragraph 6, this witness has very categorically admitted that Chutar Mehto, Deva Mehto, Beni Mehto, Baiju Mehto, Suma Mehto, Bhiku Mehto, Veena Mehto, and Dibu Mehto are all cousins interstate relation-wise, and admitted that there has been no partition till date. The court held that the relationship of co-custody between Bhiku Mehto and other branches of the plaintiff and defendant stood established alone on the basis of this evidence. And there was no reason to disbelieve the statement of this witness. The court then observed that defendant number 10 and 13 had also filed written statement where admitted that Budhia Sokyar was the co-partner the learned court ultimately came to finding in paragraph 13 that the issue number 8 is to be decided in favor of the plaintiff on account of evasive nature of denial by the defendant and positive and cogent evidence suggested and given by the plaintiff, and held that Budhia Sokyar, recorded tenant of Khata number 33, was a descendant of J.L. Mehto. This court finds that the learned trial court, this court finds that it was never the case of the plaintiff that the contesting defendant belonged to the it was never the case of the plaintiff that this court finds that it was the specific case of the plaintiff that Bhiku Sokyar was belonging to their family, and there was a common ancestor, and it was a specific case of the contesting defendant that Bhiku Sokyar was an alien to the family. However, the learned trial court was of the view that in spite of such stand taken by the contesting defendant, it was for the defendant to prove as to who was the father of Bhiku Sokyar. Further, the learned trial court has not considered any of the oral evidence of the plaintiffs and has recorded findings. The learned trial court, while considering issue number 7, the learned court considered issue number 7 pronounce कर देते हैं हम लिखा देंगे. I will allow it partly, only in connection with खाता number 20. 33, that is not. Partly allowed.